Hi, I'm Aslam Mullah and I am a registered attorney, and in today's video we're going to be talking about a sensitive topic, but it's a very important topic to discuss because it's highly prevalent in today's society, and the topic is sexual harassment. We have already done a video that's aimed at people who are victims of sexual harassment and are genuine victims and going through this experience. The purpose of this video today, however, is the flip side of the coin, which is somebody who is falsely accused of sexual harassment. In other words, there is no proper evidence, they are genuinely innocent, but somebody at work has accused them of sexual harassment. We are going to cover in today's video what is sexual harassment, some of the brief examples, and also what are your rights if you are falsely accused of sexual harassment. So let's get started with it. Sexual harassment in terms of the law is any uninvited and unwelcome conduct of a sexual nature. Uninvited and unwelcome conduct of a sexual nature. That's the definition. Examples will be physical contact, inappropriate jokes, inappropriate communication, etc., etc. However, the important thing to bear in mind if you are being falsely accused of sexual harassment is that there must be proper evidence against you. In other words, there must be objective evidence that this person who's accusing you must have against you, firstly. And secondly, the company must properly investigate the matter. They cannot simply rely on a statement that this person has issued against you. In other words, this incident must be properly investigated, and it also must be kept confidential. That means no one in the company must know about it unless they are directly involved. The reason why is that because your name is now being tarnished. You are now being painted as this kind of evil harassment kind of person, whereas the truth is there's no proper evidence. Now, speaking about evidence, there's two aspects that we must cover. The first is objective evidence, and the second is in essence just witness testimony. Objective evidence means evidence that is independent of either you or the person who's accusing you. What do I mean by that? Objective evidence would be emails, phone call logs, WhatsApp messages, etc. Those are things that are hard to dispute and it's independent. It just exists. And the second is just the accuser's testimony. So where there is objective evidence, you must properly assess that objective evidence. You must challenge it to say, was it properly obtained? Was it entrapment? Was it sent in the right context of the conversation, etc.? Where there's just the witness testimony, it is your right to challenge that testimony. In other words, when the matter is at the disciplinary hearing stage or at the CCMA, that person who is accusing you must come on the witness stand, and it is your right to cross-examine that witness. It is your right to put your version to them. At the end of the day, the company cannot fire you unless there's clear evidence of sexual harassment. You are going through this accusation, you are being painted in a negative light, it is your name that is being tarnished, and this must be properly investigated and properly examined. So, a real life case scenario that we've got at the moment is where two people are in a management position, and the person who's accused our client of sexual harassment does not have the objective evidence. And in spite of that, she went ahead and accused our client. When it came to the disciplinary hearing, our client was able to properly put his case to her. There was no objective evidence, there was no witnesses, plus her testimony was contradictory. She said the harassment had occurred at a certain day, at a certain place. However, in her testimony, she said something else. Basically, there was her witness testimony was not very credible, and our client was able to vindicate himself and his name was able to be cleared. So, in summary, sexual harassment is a very serious allegation, and you have a right to defend yourself and you have a right to inspect the evidence. And more importantly, the company must properly investigate the matter before they take any action against you. If they take any action without properly investigating the matter, or the evidence is not very clear, it is your right to take the matter to the CCMA and challenge the matter so that your name can be cleared. If you need help in your situation, you're more than welcome to click the link below and book an appointment with our office. I wish you all the best, and I'll speak to you soon.